All right, wonderful people, welcome back to this wonderful channel where we bring you back-to-back update and information as it is hot. In case it's your first time of joining us on this wonderful channel, kindly go ahead and subscribe, like, comment, share, and also remember to on your notification button so that whenever our news drop, you could be the first. We'll collect them. Let's go down to the news proper as it is hot. They say as he be now, Bayasade for Katakata, Asari dokubo himself, don't collect Choma Jungwa. Then they find him way, because Asna Ebukota, Isikote Ebu Megene, or Bakasian isi. I been heard you want when he wants to measure a man, it is not by words, but it is by action and what one has done. As they be now, as they go now, as security firm don't deny say they get involvement in Bayelsa community military invasion. They say military people don't enter Asari dokubo Bayelsa then side come scatter everywhere. But the matter where we say in the sub, we say the military don't deny say they get hand for that matter will happen. But the people will come carry out the action. Now military people, they do for uniform, they carry their car. But they are them for the top. They say, they don't know the people who can't do the things will happen. And I want to ask, before I will bring you the full details of this information, if this kind of things are happening in Obodo, and I be say trouble there, because police fit carry you, deny say they carry you. They not gonna know where they carry you go, or police fit come, do anything. You not gonna know whether na police or army or cutuma or even Navy do. May we go down to that, to the full detail of the information. Tanita Security Services Nigeria Limited has refuted any involvement in the alleged military combat invasion of Ibomoturu in southern Ijo local government area of Bayelsa State, which resulted in Sunday's protest by the people of the riverine community. The firm stated this in a statement signed by its coordinator, Bayelsa Operations, Joshua Masiva, on Monday, while reacting to a media report on the incident and the claims of the community. The Punch report that the youth, men, women, and chief of Ibomoturu staged a peaceful demonstration in the community on Sunday in several videos posted online claiming that the military onslaught was as the instance of Masiva, who was at the All Progressive Congress deputy governorship candidate in the just concluded governorship election in the state. They also alleged that Masiva masterminded the invasion to oppress them and also install one Friday Jonathan, who had been rejected as the paramount ruler of the community, adding that the APC chieftain was using his links with Tanita to reportedly cause mayhem in the community. I no want to read for you long readings, carry them they go, because you find out that nowadays politicians, be like say wetin they do this time now by fire by force. So if you no want to make they rule you, they must rule you. If you want to make they rule you, they must rule you. You say you no want them, whether you like it or not, they must enter that office. I can see that. That is the kind of politics that we have found ourselves into, and the kind of democracy that we have found ourselves into. And onya asino Jacobolo no na ya kama si onya na bonya na ba ka everybody na ba na their own land elu anu no ndị ọbụla malụ ntu ha ga-esi kpezi their own ha esi kpezibe biafra kwenu ya Oduduwa kwenu ya Arewa kwenu ya asị onye megene onye ọbụla na ba bie. The council Thomas Nnamdi Kanu Aloy Ejimako don't talk say he say he have some reasons where we say Nnamdi Kanu will never be tried in any Nigerian court. Now Aloy Ejimako na in they talk this one say as he be say Mazi Nnamdi Kanu will never be tried again in any Nigerian court. Let's go for the full details of that information and see Aloy Ejimako's reason. He said more reasons Nnamdi Kanu can never be tried in any Nigeria court by Aloy Ejimako following his infamous extraordinary rendition. Mazi Nnamdi Kanu was on 29th of June 2021 secretly arraigned and without benefit of his counsel of record before the Federal High Court, Abuja, on the 4th count pre-rendition charges standing against him as of that date. The charges were namely treasonable felony, conspiracy to commit treasonable felony, illegal importation of radio equipment, and defamation of President Buhari. In extradition practices, these charges are known as pre-extradition charges or pre-rendition charges, such as this particular case. Subsequently, in a slew of amendments of charges, the then Attorney General of Nigeria, Abubakar Malami San, withdrew all but one of the said 4-count charge and replaced them with an entirely new set of 14-count charges that all bordered on terrorism and membership in a proscribed organization. In the course of time, the Federal High Court, pursuant to application made, reduced the charges to 7-count charge that were later quashed by the Court of Appeal, thus leading to the celebrated judgment discharging Nnamdi Kanu and barring his trial in Nigeria. Without prejudice to any live judicial proceedings currently pending and concerning Nnamdi Kanu, the public has a right to be informed of whether, after the rendition, it is legal for the Attorney General to abandon the pre-rendition charges and array a whole new regime of charges against Nnamdi Kanu post-rendition. The simple answer is that it is illegal, and below are the reasons. Under the universal recognized doctrine known as the doctrine of specialty, which pertains to extradition or fugitives transferred from another country, is subject to prosecution only for those offenses for which he or she was transferred. But where his transfer failed, the muster of the law or constituted a rendition, he is not to be subjected to any trial or detention but promptly returned to whence he was brought. This is common law, and Nigeria recognizes and enacted at Section 15 of Nigeria's Extradition Act, which provides as follows: where, in accordance with the law of any county within the Commonwealth or pursuance of an extradition agreement between Nigeria and another country, whether within the Commonwealth or not, any person accused of or unlawfully at large after conviction of an offense committed within the jurisdiction of Nigeria is surrendered to Nigeria by the country in question. Then, so long as he has not had a reasonable opportunity of returning to that country, that person shall not be detained, whether under this act or otherwise, tried or otherwise dealt with in Nigeria, or in respect of an offense committed by him before his surrender to Nigeria, other than a. the offense for which he was surrendered, or any lesser offense which may be proved by the facts of which his surrender was granted, or b. any other offense, being one corresponding to an offense described in Section 20 of this Act, of the same nature as of the offense for which he was surrendered, provided that a person falling within this section shall not be detained or tried for an offense by the virtue of paragraph of this section without the prior consent of the country surrendering him. To be sure, the foregoing provisions were, as regards Nnamdi Kanu, breached in all their material particulars. First, as of the 19th June 2021, when Nnamdi Kanu was abducted in Kenya, he was facing a 4-count charge, none of which included or bordered on terrorism or proscribed organization. Today, the charges have been expanded to 14 new counts, of which virtually bordered on terrorism. Unarguably, this is a clear violation of the doctrine of specialty, especially in view of the proviso that a person falling within this section, i.e. Section 15 of Nigeria Extradition Act, shall not be detained or tried for any new offense without the prior consent of the country surrendering him. This is also a double whammy. Assumes a double whammy because bringing up these new charges assumes he is, consequent upon the rendition, triable for the pre-existing charges, which is wrong. In this particular case, the surrendering country is Kenya, and there is no evidence that her consent was obtained before these new 14-count charges were brought to be sure. This section 15 of Nigeria Extradition Act is ironclad, as it went further to absolutely bar detention and trial of such person under any other law, like the Administration of Criminal Justice Act (ACJA) or the Terrorism Prevention Act, which the prosecution had sought to use in Nnamdi Kanu's case. To be clear, this is evident from the opening provision of Section 109 of ACJA, which made commencement of criminal proceedings subject to the provision of any other law. In this case, that other law is the said Section 15 of Extradition Act, because Kanu was brought from another country, and by the rules of conflict of laws, the Kenyan Extradition Act also applies in the centennial. My people, when I don't see as they go, all this big English where you hear be say, waiting alloy Ejimako they try tell you be say, as they be, according to the law, say Mazin and the Kanu, they no supposed to try him again for any Nigerian court. Say if anything should happen, they should carry him back to Kenya. As they be, and I hear Kikena go, and I hear I go the Usawala. Thank you for listening. God bless you.